That is information for you to study before the chair's meeting next week.
You won't sleep now.
No, I won't.
Good evening. I'd like to call the April Health and Human Services meeting to order. Welcome, everybody. We'll start out with privilege of the floor. If you'd like to speak to the committee, please step forward, give your name, and continue from there. Thank you. Hold on one second. Mike.
Yes, good evening. I'm Jennifer Constance, and I do have a packet that I prepared for each of you. There's a few more of you here than I expected, so if you wouldn't mind sharing, I do have 8, so I'll come and pass them over here to the left. You can just pass them around. time, good evening. My name is Jennifer Constance. I'm a 24-year veteran employee of the Jefferson County Department of Social Services. I am the coordinator of the Jefferson County Child Support Enforcement Unit, and I answer directly to Commissioner Teresa Gaffney. I have held this position for over a decade. Prior to that promotion to that county management position, I was a senior support investigator prior to that title. I've been a member of senior management at DSS also over a decade, and I meet weekly with our senior staff counterparts and from the different program areas and the commissioner. We discuss and develop policy and management of our agency. I am a sworn designee to the commissioner. I sign all paternity, foster care, child support modification, violation, and interstate petitions to the courts, filed on behalf of the department, and as designee to the commissioner. I am responsible for signing proofs of claim for bankruptcies on behalf of DSS for all child support cases and management of over $15 million each year collected by my county office. My staff engages daily with the Jefferson County Attorney's Office and the courts. I'm responsible for all direct reports in the child support program and the Jefferson County Support Collection Unit. I am a member of the JCDSS North Country Coalition as a representative with Teresa and other senior management and supervisory staff. I also was designated by the Commissioner as one of 3 agency employees to serve on an administrative review panel to hold reviews of shelter-plus care cases that resulted in termination of benefits to our agency's clientele and make the decision to overturn or affirm that program's decision. I was also appointed by the Commissioner as supervisor of the Jefferson County Fraud Investigations Unit simultaneously with my duties to run the Child Support Enforcement Program. I attended the Night with the Fraud Institute and worked with law enforcement agencies, parole offices, and the Jefferson County DA's office. During my time as supervisor, that unit was recognized by this board for outstanding performance. Last, I also was designated by my commissioner as the terminal agency coordinator, in which it was required that as the TAC, the New York State Division of Criminal Justice, had to clear me through their approval process and the background investigation clearance through the Federal Bureau of Investigations. I am exclusively responsible for requesting and reviewing criminal background investigations and review the law enforcement responses directly as well as the fingerprint results from the New York State Division of Criminal Justice for all prospective employees of the Child Support Enforcement Program. I am an administrator. I am a co-worker in this county. I am a team player. I am a property owner, a taxpayer. I am a mother, a friend. I am a contributor to my community and my agency. I am educated, I am trained, and I am dedicated to my staff and the health and well-being of the people we serve and the families that so heavily rely upon us to be stewards and decision makers in the times of crisis and with their social and economical needs. We are interveners in the most delicate, private, and endearing parts of their personal lives, and we are all too often the final decision makers of the future impact on the rest of the lives of their children and their entire family structures. So this is why I have remained motivated, dedicated, and disciplined, and guarded in my management and handling of the great responsibilities that have been entrusted to me and the staff that I am responsible for. This takes responsible leadership. It requires review and communication, dissemination, consistency, oversight, correction, and recognition if there is to be any guarantee of the greatest chance of success. Not only at the consequence of our own positions or our staff, but above all, to the people who don't know what we know, who aren't equipped to and most often don't possess the resources without us. There is a mission statement that hangs at the entryway of our DSS lobby, where each day remains as a reminder to all of us what the purpose of our day is and to whom we owe that constant representation. And it is to the children and the families of this community. My children, your friends' children, your relatives' children. We are accountable for what we are paid to know, to understand the laws, the rules, the regulations, and our policy directives. We are paid to follow through and apply those procedures in each and every case. Isn't that what we earn our wages for? Isn't that how we maintain our positions? I come before you this night not as a disgruntled employee, not to complain about my wages or staffing needs, and you have heard me now lay the foundation of my background as it relates to my agency, this county, and to you as a committee of representatives with the power and authority to bring change. to regard and to hold us accountable. You have heard from me on how I give of myself to serve my staff, my agency in this county, and now I share with you a more personal and deeply passionate part of who I am, and perhaps the most important role that was ever naturally given to me, and that is being the grandmother to now 4-year-old Kendall Constance, and her picture is included. And please make no mistake as you listen to me and plead my case, and when you hear me now and when you leave this night, you will understand that there is no higher or more important job or responsibility than that I have to her. And I talked about dedication, and I am fiercely dedicated to that little girl that too was thrust into the hands of strangers in the churning system of child protective and foster care placement. But before I go any further, I'm not here tonight, and I did not make this difficult decision to come forward publicly because I seek pity or empathy. I come here for help and to seek action when I couldn't obtain it from those in which who could have and should have made a difference. I ask you to write 2 words down for me, please. Family Court Act 1017, FCA 1017. I have the law for you here tonight. I've highlighted specific mandates that my department, my commissioners, and our delegate staff are required to follow. It is not optional. It was not optional when my grandbaby was thrust into the system. Before I leave you tonight, you will know the importance, the impact, the foundation, and the undeniable consequence of that legislation, the law, and the mandate. I will try my best to make you feel and see the significance, because I can tell you firsthand the horrors to a child and a family should Family Court Act 1017 be disregarded, overridden, circumvented, and downplayed. Because I am living it, we are living it. The 2008 federal law, Public Law 110-351, titled Fostering Connections to Success and Increasing Adoptions Act reads, Notification of Relatives. Section 471 of the Social Security Act, as amended by Section 101A of this Act, is amended, and it provides, quote, that within 30 days after removal of a child from the custody of the parent or the parents of the child, the state shall exercise due diligence to identify and notify notice to all adult grandparents and other adult relatives of the child, including any other adult relatives suggested by the parent, subject to exceptions due to family violence. A, specifies that the child has been or is being removed from the custody of the parent or the parents of the child. Kendall was removed from her mother. Kendall's father is my son, Brandon Constance. B, explains the options the relative has under federal, state, and local law to participate in the care and placement of the child, including any options that may be lost. Let me repeat that. Including any options that may be lost by failing to respond to the notice. C, describes the requirements under paragraph 10 of this subsection to become a foster family home, and the additional services and supports that are available for children placed in such a home. And D, if the state has elected the option to make kinship guardian assistance payments under paragraph 28, describes how the relative guardian of the child may subsequently enter into agreement with the state under section 473D to receive the payments. And yes, my agency is a participant in the kinship program. Also, same public law 110-351, section 3954. 2, intensive family finding efforts that utilize search technology to find biological family members for children in the child welfare system, and once identified, work to establish relationships and explore ways to find a permanent family placement for the children. Further, New York State law, Family Court Act Section 1017, here we go again, mandates DSS as follows, quote, in any proceeding under this article, when the court determines that a child must be removed from his or her home pursuant to Part 2 of this article or placed pursuant to Section 1055 of this article, A, and I highlight, the court shall direct the local commissioner of social services to conduct an immediate investigation to locate any non-respondent parent of the child and any relatives of the child, including all of the child's grandparents, all relatives and suitable persons. The local commissioner shall inform them in writing of the pendency of the proceeding pending in family court, and of the opportunities for relatives to seek to become foster parents, to provide free care under this article, or to seek custody pursuant to Article 6. Uniform statewide rules of court shall specify the contents of the notice consistent with the provisions of the section. The local commissioner of social services shall report the results of such investigations or investigations to the court and parties, including the attorney for the child. The local commissioner shall also record the results of the investigation or investigations in the uniform case record maintained pursuant to Section 409 of the Social Services Law. That would be Kendall's case on their connection system. 2B. The court shall, upon receipt of the report of the investigation from the Department of Social Services, order pursuant to subdivision 1 of this section, where the court determines that a suitable non-respondent parent or other person related to the child cannot be located, remand or place the child with a suitable person. As far as Kendall's entire paternal family and myself, specifically as her grandmother, my notification would never come. I was not sent the mandated letter titled Notification to Relatives, and I have a copy of that notification letter for you in your packet where it spells out the rights. Please see that. It's very crucial, as you'll see forthcoming. It was sent to the grandmother who Lindsay and Kendall live with. She's over here. Her name's Denise Murray. I was not called. I was not emailed. I was not contacted to discuss all of my rights as denoted in the notification letter, the federal law, the state law, the administrative directives from the Office of Children and Family Services, and their own CPS New York State training manual. I was not contacted to discuss all of my rights. There was not as much as an attempt. I was not advised by my commissioner or a single representative of my rights to intervene as an interested party for Family Court Act 1017, Public Law 110-351, New York State Directive and CPS Manual, New York State and the Family Court Unified System, multiple court orders, they're coming. Advised of my right to file for custody or of my right to become a foster parent or to apply for kinship guardianship and receive kinship guardian assistance. I was not provided the kinship handbook, and there was no investigation, there was no diligent effort made to contact me. And therefore, nor was there a record of their efforts and investigation and the result of that investigation recorded in Kendall's uniform case record as also mandated by the laws discussed above. My parents nor my brothers were contacted or notified, nor was Brandon, Kendall's father. His father was not contacted either. An entire family was disregarded, and this child was entitled to every single one of those opportunities. Nor did DSS discuss with us the options that may be lost by failing to respond to the notice. If it's not enough that the laws, rules, and regulations clearly define the department's controlling role, my department and commissioner specifically were also under multiple court orders throughout the 7 months that Kendall remained with a foster family. The agency is under New York State administrative directives. They attend training academies that we pay for, you pay for, and have supervisors and legal staff that meet, and they discuss their reports and their presentations to the court. They sit in our court building, they have a room. And their testimonies in those cases. Family Court Act, New York State Law 1017 is standard operating procedure for caseworkers and supervisors, and there's a complete section, Chapter 9, in their CPS training manual. It's provided by their state office, Office of Children and Family Services. This is not optional. It is not to be manipulated or circumvented because they obtain an outside resource and would prefer to move the child as soon as possible. It's the law. It dictates where and with whom our children are placed with, and most often, where they will remain until they reach the age of majority. The options that may be lost by failing to respond. So now you know what was supposed to happen, and now let me explain how it actually went, and how it's been handled, and the detrimental aftermath of the consequences to myself, to baby Kendall, and our entire family. Who also, I have family from Pennsylvania that are immediate relatives to Kendall as well. Kendall was taken from her mom, and it was appropriate at the time that then 3-month-old Kendall, Constance, was removed from her mother, Lindsay Holliday. I have releases here signed by Lindsay. She's very sick. Her mother's here. Kendall's father, Brandon Constance, was incarcerated. Brandon has a history. Brandon was not notified by CPS for a week that his daughter had been removed from her mother, and Kendall was placed into foster care. Brandon was at the Jefferson County Metro Safety Building at the time. I think it's about 10-15 minutes down the road, not even. But they had been in contact with a non-relative within 24 hours of Kendall's removal. And her name is Amanda Bush. They had their resource, as they like to deem it. And as Teresa later informed me personally, she believed they had stopped right there. Per Amanda Bush's petition, an addendum for custody filed within 24 hours of Kendall's removal to the family court, quote, DSS urged me and assisted me in filing a petition to family court the very next day after they had taken Kendall from her mother. DSS informed her of the upcoming court date, first one being having to be held within 72 hours of Kendall's removal so that they could have official permission and an order to remove the child. A court date against Lindsay Holliday, the mother, which was Article 10 neglect proceedings. And if for anyone in the room that isn't aware, Article 10 proceedings are not regular family court proceedings. It's not like tonight. It's not like 5-file custody. An Article 10 neglect case is a private, closed matter. The law specifically states that there are 4 parties by name that may even intervene in an Article 10, participate, or even be present in the courtroom. That is a grandparent, an aunt, or an uncle. That is it. That's family court law, New York State consolidated law. Per the law of the Family Court Act, an individual does not have a right to intervene in an Article 10 proceeding unless you are the grandparent, aunt, or uncle to the child, and then you may file a motion to intervene as an interested party. And the courts are encouraged to approve such motions. Amanda Bush was certainly not a grandparent, nor an aunt, or an uncle. However, on March 27, 2018, DSS prepared and certified a sworn document called a permanency hearing report. I have that here. It was submitted to the family court judge on April 18, 2018, which was the simultaneous date of the permanency hearing. In this report, in each instance, 3 instances, the department who authored the report via the caseworker, Jessica Gilchrist, signed by Supervisor Sarah Hoystian, certified by Christopher Stevens, DSS legal attorney, representative, they list Amanda Bush as paternal aunt to the child in each instance. And perhaps even more egregious, they submitted this sworn report stating, quote, that all grandparents have been notified and made aware of Kendall's placement, and that the only interest from a relative was Amanda Bush, paternal aunt, again. And what did my department do when they have had multiple chances over the course of the last 3.5 years that my litigation remains pending, when they know that the department holds great influence with our family court? What was my commissioner's response when I personally made her aware of what had specifically transpired when I contacted her and requested to speak with her directly to discuss the significant situation? I will demonstrate to you via their written responses that they are interested in nothing more than liability and, unfortunately, cover-up. First, they exclude me from my opportunity to become an interested party, and as I was entitled. And when I learned of the circumstances that transpired with my granddaughter and my department from September 2017 through June 2018, and I hire an attorney out of Syracuse and throw money at this situation for the last almost 4 years, I filed the necessary motions and paperwork in the court to reopen the matter. As per the CPLR, Civil Practice Laws, Rules, and Regulations, they file actions to suppress me, to request dismissal. They refuse subpoenas. They file motions to quash my subpoenas for caseworkers to authenticate their own reports already submitted to the family court in my granddaughter's case. They deny access to the parents to documents that would assist our case. And as the parents are direct parties, again, the CPLR provides that those parents, as respondent and non-respondent direct parties to the matter, are entitled to all reports in the uniform case record and held by the Department of Social Services. Their attorney screamed and swore repeatedly at my attorney outside of the judge's chambers. F you, F you, F you, F you, F you, F you. And there's 3 people here right now that witnessed it. Because he simply asked for the 14th time, will you produce the caseworker? F you, F you, F you. They submit motions and responses to judges that state that my motion to reopen should be dismissed. They even claim in their responses to the court that I manipulated their caseworker's testimony. I don't know about you, but if I'm asked a yes or no question under oath, I have 2 options, yes or no. You cannot manipulate, you cannot twist a yes or a no. And they use 2 platforms to shirk their neglect and mishandling, and this is what you will hear from my department should you ask for an inquiry, because this is what I have heard. This is their only explanation to deflect. They repeatedly state that I was not a party to the original proceeding involving Kendall, and therefore I have no lawful right to request relief or motion the court to reopen or vacate that original order that led to Kendall being placed into the permanent custody of a non-relative, a woman who did not know the child, a woman who did not know the mother of the child, and to a woman who barely knew my son. The second and only other platform they respond with is that this was the parents' choice, where their daughter was placed. Parents' choice. This was the parents' plan. Parents' plan. Parents' choice. They stated that the parents have every right to choose who has custody of their daughter, and that choice wasn't for the child to be with the grandmother. What a load of malarkey. And if anyone knows anything about Article 10 cases and how they are handled by my department and in the current court environment, then you know perfectly well that is the furthest thing from the truth, and not the case for Kendall and her parents. And if you don't, I implore you to follow through on research of this case. Go sit in the court and in their conference rooms that CPS and one of our 2 attorneys sit in for hours. Then you will see who is in control. Make no mistake, the parents are not in control. Child Protective dictates what the plan is. They create the plan. They write the reports. They tell the parents, this is what we're going to do. You're on board or you're not on board. We'd love you to be on board, but if you're not, the steamship goes on. The parents don't make the plan, they do. These parents in Article 10 neglect cases obviously have issues. Many are severe or have multiple levels of needs and addictions and little to no resources at the time. They do not know the rules. Let's not pretend these guys and girls know these rules. They're on drugs. They're in jail. They're suffering. Yes, they're neglectful. Absolutely. Kendall was neglected. I didn't know about it. I should have known about it. They do not know the rules. They don't know the intention of the caseworker's plan for their child until they are told what DSS finds acceptable. Then they make their monthly contacts and they write the reports, and obviously they choose how they're going to conduct their so-called investigations. And where is the oversight? I'm almost 4 years into it, and I'm still scratching my head, and I'm still begging for it. I want it. I need it. Kendall needs it. Damn it, somebody's got to do something. I give my all when I go to work every day. Hopefully you do. I'm pretty sure you do. That's why you're all here. We elected you. You have kids, you have grandkids, even if you don't. Somebody you know, somebody you love, they have kids. So do I. And they're not perfect. But that grandbaby's dang near close to perfect. And she deserves better. I don't want to hear any excuses about, oh, the parents. The parents what? The parents aren't held to the law. It's not the parents' responsibility. We're in that law that I gave you. We're in their directives. We're in the federal law, state law, administrative directives. We're in the family court orders. Does it say anywhere that Lindsay Holliday was responsible for telling the department and informing the parents of their rights? Where in those orders and laws anywhere that the legislators at the highest level pushed through, the president signed into law? Where was it saying that Brandon Constance had to tell Jennifer Constance, and oh well, sorry, you should have known? That's not what that says. For obvious reasons, because families have problems. People that are involved in child neglect cases and have their children removed have problems. What's one of the most biggest problems? They have a miscommunication with their own internal families. That's exactly what my situation was, and sometimes, to be honest, it still is. My son has problems. He's not there for Kendall, and he's not calling his mother. When I don't hear from my son, he's got problems. Does that change the law? Does that change what our legislators put down? Was that the intent of the law? No. Dang it, if that was the intent of the law, it would have said and, or, but, and, forthwith, parents also are responsible in this. That is not what the laws say. That is not what our CPS workers are mandated to do, and that is not what our DSS attorneys are there certifying. They're presenting the case to the family court judge. It is not okay to say, like the law guardian says, that fixes Christopher Stevens' tie every time we're in there. She should have known. Oh well, sorry. We had a resource, and they had a chance to throw your name into the ring, but they didn't. I work literally within feet of the same individuals, and for 7 months. Why? There's no excuse. You cannot deny this. You can't push it off. You cannot. But that's what's happened to me. I am $65,000 into this because I'm dealing with a magistrate on day one of the trial who says, with DSS in there as an interested party, I'm not going to see the county get brought down. That's on record. Again, 3 or 4 people with me tonight sat in that courtroom. What am I to do with that? How far do you think Jennifer Constance is going to get against DSS? DSS, who sends 75 to 80% of the business to that family court between child support and children's services. It's all black and white, don't take my word for it, it's their words, their sworn documents, their testimony. When my granddaughter had been in care from 2017 to April 2018, they were preparing to request the court for a temporary change of placement from care to their resource, Amanda Bush, who cannot do that until a permanency hearing, which has to be 6 months from the time initially in care. They knew the birth mother, Lindsay, had been visiting her daughter weekly at the agency, my agency where I walk in every day, and she was not in agreement to Kendall being placed with a woman that was not a relative who she didn't know, she knew Kendall did not know, and had never even met. She refused to consent to her daughter being moved even when they continued to pressure her. Lindsay Holliday testified to those facts during our pending custody trial. And Lindsay is very difficult to get anywhere at any given time. And the girl made it there 2 days in a row. Nobody expected her to show, but she did. And she testified. And her mother is here, who also was there. So in March 2018, they suspended Lindsay's visits with Kendall. Lindsay had relapsed. They're justified, okay? They immediately began allowing Miss Bush to begin visiting Kendall so that she could meet my granddaughter and form a bond, quote, in their permanency hearing report. So Amanda meets Kendall for the first time mid-March 2018. So within less than 30 days of Miss Bush meeting the baby, initiated by them with visits at our office, they report a false and misleading report to the court and had filed a simultaneous petition requesting to put Kendall with this woman inside of a month of her meeting the baby. Important to note, the court's decision to agree to the change of placement on April 18th was not based upon the request of Kendall's parents. Nowhere in this permanency order that I have here will you see that. Nor will you see it in their permanency hearing report. This is what you will read. Judge Langone. It was solely based upon JCDSS testimony and reports. I have that order also. Here's another direct problem. Again, don't take my word for it. I have a copy of the October 18th, 2017 home study report that will demonstrate that DSS manipulated the facts, and it's their own records that show this. DSS caseworker Larry Goodwin concluded from his interview with Amanda Bush at her boyfriend's house that she reported in the home study report that Miss Bush and Brandon Constance were not related. Okay, let's back up. So you do a home study report of this girl in October of 2017. You print it, and it's provided to the Jefferson County Family Court judge. And you say, she's not related. She feels like she's family, but she's not related. In March, 5 months later, when it's time to do a permanency hearing report, you put in your report, she's the stepsister. She's the paternal aunt. 3 times, every time. No mention of Jennifer Constance. No mention of Stephen Myers. No mention of Stephen Myers Jr. No mention of John Constance. No mention of Jason Constance. No mention of J. Michael Cantino. And no mention of Vicky Cantino and Joseph Cantino. None. The only interested relative, Amanda Bush. A permanency hearing report is a sworn document. It's in the law, Family Court Act. Again, it was the sole basis, including with the testimony of the JCDSS caseworker, that is why the change of placement went from Kendall going from foster care to the non-relative Amanda Bush. If we want to jump ahead real quick, the date of that order was April 18th, 2018. Amanda met this baby in March, mid-March. So you got her moved over to this gal, you rip her out of foster care where she was for 7 months, and on June 21st, April to June 21st, Kendall's first birthday, signed, sealed, delivered. Done deal. full permanent order of custody. We skipped past the permanency hearing goal. You know, the permanency hearing goal, that was to return the child to the parent. There was a couple quarters in between where Langone had it in his order. The department's still going to require that the department, the Commissioner of Social Services, uses their diligence and their efforts for family finding, locate all grandparents and relatives. Never happened. Mama didn't show up. Default. Daddy's by phone. He's in a rehab, out of town, no lawyer, whole entire time. That's in the Family Court Act too, by the way. Non-respondent father has to be entitled to legal counsel. That never happened. On record. Never waived his right for an attorney. They called him 3 times. Coincidentally, the 3 times that they called him were on the court dates where change of placements were occurring. Okay? And they got him to consent. Want to know why? He wasn't talking to his family. He was locked up and immediately sent to an intensive rehabilitative program out of county. He didn't have a clue what Article 6 or Article 10 and what those differences are. He was told, listen, these adoptive parents want to adopt Kendall. And Brandon, you don't got a lot of time, because if it hits 12 months and Kendall's in care, they have the right to seek adoption. You got Amanda here. Do you got a problem? Would you rather see Kendall go with Amanda? Yes, he did. He thought at least it's somebody he knew. Again, there's children that should be removed. Kendall was one of them. And there are some good things that CPS does. Of course there are. There's some great people. But let me tell you right now, if this can happen to me, it can happen to anyone. And I can guarantee you, it has most definitely happened before me. People don't have the resources that I have and that I was willing to put into this. People don't have the time, they don't have the strength, they don't have the willpower, they don't have the education. I have spent hundreds of hours doing legal research. I already told you almost $70,000. It's going to cost me $7,000 more for 2 days of trial coming up in less than a month. $7,000. And this is what I keep hearing. She wasn't a party. She wasn't a party. Oh, I'm sorry. The CPLR said you only have 1 year to reopen. I did try to reopen. Let me read you how my department responded. So you now know what happened. It's in writing. You can't escape it. You can't excuse it. You can't make it something that it wasn't. It just simply was. Christopher Stevens, CSS legal representative, Jennifer Constance, through her attorney Vincent Finocchio, out of Syracuse, once again tries to reopen the matter. Goes in front of a new judge, a criminal judge, who's an acting family court judge, because the original family court judge recused himself for obvious reasons. I sent petitions to the court. I worked directly with the family court. It was the appropriate thing to do. However, he's coming into this blind. Complicated matter, he said. Very complicated matter. Well, to be honest, it's not a complicated matter, now is it? It's not complex at all. It's pretty simple. You're to do what the law calls you to do. You cannot disregard an entire paternal family when a child is removed. You cannot do that. And you knew that. And you wrote about it. And you falsified it. I love my job. I love my agency. I am a dedicated employee. But I was failed. And Kendall has failed. Our family has been failed. I have workers who are here. They can spend their time somewhere else. But they understand, and it creates fear in them. And you know what that fear is? this could happen to me. If that can happen to Jennifer, it can happen to me. For what reason? No reason. No excusable reason. So Christopher Stevens files affidavit opposing motion to vacate. Mind you, we're already in the trial. The caseworker took the stand, okay? And he files affidavit opposing motion to vacate. Christopher Stevens, being duly sworn, deposes and states, I'm the attorney of record for DSS. I make this affidavit in opposition to the motion to vacate the final custody order regarding the subject child, Kendall Constance. First, as stated in the affidavit of support of motion, a post-trial motion pursuant to CPLR 44-4 must be filed within 15 days after a court's decision. Here, the order is appealed from over a year old, so the court should deny the motion. CPLR 4405. Now, mind you, let's keep in mind, we just came off the trial where I got the caseworker's testimony, dead to rights. And I'll read that to you quickly. It's just a few questions. Pretty impactful. Further, case law suggests, you have the case law, I just read it to you. Case law suggests that the court has authority to set aside a decision to relieve a party. In this case, the grandmother was not a party, as the law envisioned. Now, you mean to tell me that you can honestly put something in writing to say that the law did not envision a grandparent to be an interested party in an Article 10 removal case? How many more pieces of law do we have to go over? It is true that she may have had many of the rights of a party as a subject child's grandparent. Here, she was never an actual party to the litigation. I wonder why. I think we all know why Jennifer Constance wasn't a party at this point. It's pretty clear. That being the case, the grandmother does not have standing to request the final custody order be vacated. It should be noted that the burden is hers, and all the case law presented in support of the motion involves petitioners. She is not. Frankly, none of the case law proffered is on point regarding whether an interested party grandparent can file a motion to vacate a custody order that was consented to both parties, the biological parents. Second, the grandmother argues that she is entitled to a custodial preference pursuant to Family Court Act 1027. However, there is no such preference granted in that statute. Well, that's wrong, because Family Court Act 1017, Public Law, Federal Law 110-351, and Family Court Act specifically 1017-2B perfectly contradicts this garbage. The law is the law. It's in black and white. This is a manipulation of a judge that came in and didn't know what the heck he had on his hands. But I've got the driving force of the Department of Social Services, who did not remain silent, who did not show any willingness whatsoever to say, you know what, let me talk to Dave Paulson. Let me talk to John Sabick. We got to be able to do something here in the interest of justice. If I wanted to sue, if I wanted the county's money, I've had 3.5 years to do that, and I don't care about the money. I'm giving. I want my granddaughter. That's what I want. I want her in the home where she belongs. DSS clearly had the power. They were the force. They were the petitioners. They were the custodians. They filed the reports. They filed the petitions to move Kendall to Amanda Bush. They had all the cards. The judge said so in his court orders. My decision is based solely And if I'm not incorrect, does solely mean exclusively? I believe it does. On the JCDSS reports and the JCDSS testimony. Case closed. So now I try to reopen it after everything's exposed, and what do I get? I don't get any support. I get manipulation and requests to smother me, to stop what should have been done. Is really that our position? Are you guys happy with that? Is that acceptable to you? Because of liability? Is that, I don't understand. I don't understand this. My heart is broken. My granddaughter looks at me and says, Grandma, how many more days do I stay? I said, well, 2, baby. No, I stay with you all days. I am tired of the nonsense. I need help. I need people in position of power and authority and oversight. I need something with some teeth, because this family court is driven by the department's insistence that the grandmother somehow came up short. She was late to the party. She isn't a party. She should have been a party because of us, but she's not a party. So she's got to go home now. She's got to stop. She's got to be quiet. She needs to accept her little grandparent visitation. This is annoying. How long is this going to go on? That's exactly how I am given the responses every single time. For almost 4 years, I am battling this case. Now, Family Court Act 1027 requires authorized agencies, this is Christopher Stevens, again, written opposition to shut me down. Family Court Act 1027 requires authorized agencies to attempt to locate relatives of the child, quote, including any non-respondent parent and all the child's grandparents, ... and any suitable relatives. Okay. You didn't do it, but okay. Where are we going with this? After notice, interested parties can file to pursue custody, but Family Court Act 1027 authorizes the court to remand or place the child, ... with a relative or other suitable person, he says. Hint, 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 Amanda Bush. I'm pretty sure that's what he meant, because he certainly didn't mean relative. So there is no statutory guarantee, he says, that any particular resource will be granted custody. That's not true, by the way. That's not what the law says. The law specifically states that if after diligent efforts and investigation by the Jefferson County Department of Social Services, aka Commissioner of Social Services, that there is no non-respondent parent, notice I'm not reading because I know this now with the back of my hand, any non-respondent parent or relative of the child is deemed suitable, the court may place or remand the child with a suitable person. So Christopher Stevens said, now is it? So that's the other platform. Oh, Jennifer Constance is on equal ground. She's a third party. She's on equal ground with Amanda Bush. This is just a matter of best interest. This is, as Christopher Stevens, again in another response to the family court, says, quote, utterly irrelevant, end quote. Utterly irrelevant to the current custody matter. That's what my commissioner said, basically. I did go to Teresa in private, between her and I. She asked me to get releases signed by the parents so she could have a discussion. And I did that. And I took them to her. And she was gracious enough to meet with me. And I told her the whole deal. I looked her in the face. I said it was the law. I also looked her in the face and said, I will sell my house if I have to. Something needs to be done. Not just for Kendall and Jennifer and Brandon and Vicky and John and Jason and Kendall's little sisters and Kendall's mother and Kendall's father who are drug addicts, but for all those who have been before me and all those who will go after me. Because if you do not do anything after I leave here tonight, there will be more after me. Jennifer, January 31st, 2020. Time off is approved. My heart certainly understands where you are coming from and why you're asking me to do something. I have been reviewing legal documents, including the ones that you specifically asked I read. In reviewing the decision, an order on motion dated 11/26/19, the fact that you were not provided notice by the department appears to have been given and taken into consideration by Judge Renzi when rendering his decision. I honestly do not feel that my title or name is going to change the court's view or reason for denying your motion. I just read to you what the department presented in that motion. It was lies. It was manipulation. It was wrong. I may be able to make an assumption that if you had been notified, there could have been a different outcome. But I can't unfortunately say with certainty that there would have been. What it really comes down to is that there could have been another option for the court to take into consideration. I guess that meant me. But again, there would have been no certainty as to what the court's final decision would have been. In my opinion, the department stating that there could have been a different outcome at this point in time would have little impact on the custody proceeding currently before the court. As much as I would personally like to help you, and I do believe, well, I want to believe that Teresa meant that, I unfortunately am taking the position professionally that the department will not add anything further to the current proceedings. I hope you know that I have great respect for you, and I personally am hoping for the best outcome for you and your family, Teresa. Again, this wasn't easy for me to come forward. I respect the Office of the Commissioner of Social Services. I am her designee. I work and report directly to her. There is good work that gets done in that agency. That does not mean that this was wrong, that this was inexcusable and grossly negligent. No way around it. And when we say that as a department and as a response, that there may not have been able to be a different outcome, that's simply not true. Family Court Act states the only people that can intervene in an Article 10 neglect case is a grandparent, an aunt, or an uncle. So I can sit before you all tonight and guarantee you 100% with surety, in which Teresa could not, nor could her legal team, that there 100% absolutely, positively, unequivocally would have been a different result. We'll start with the fact that number one, Amanda Bush was not an appropriate or allowable by law intervener or interested party. She would not have been present. DSS told her when to appear at every appearance, had her there, were talking with her regularly, communicating with her regularly, urging her to do everything she needed to do. They had her in their reports. She sat near them for every single one of Kendall's appearances. They brought her into my building. They gave my granddaughter to her. And then in less than 30 days of them introducing her to the child, they filed a petition to have the baby put into her custody on a temporary basis. And like I said, 35 days later, bam, gone, done, case closed. It's now in Article 6. Sorry, it's over. So I can guarantee with 100% surety that there would have been a different result. And mind you, that's without even including me, or my mother, or my brothers, or Brandon's father. So please, do not tell me that, oh, we just can't guarantee there would have been a different result. That's not what the law says. I've given you the packets, a picture of Kendall. And I just want to let you know that that mission statement that I talked about earlier on, I come in every day. I don't even look up at it anymore. I believe in my staff. I believe in a lot of my colleagues, their efforts, their passion, their humanness. And I respect the offices of authority right up the chain. And I'm pretty high up there with Teresa, but she's a big deal. I respect that office. And as a person, as an individual, I have no issue with Teresa. I don't believe that she's vindictive. I don't believe that she's not a professional. And I don't believe that she doesn't put her heart into the work. What I do believe, and what has become obvious, is that it is about her position. She oversees that agency. And you cannot, under any circumstances, admit negligence. I believe her when she said on a personal level, she felt for me. And that if it didn't involve a professional liability, she'd be right by my side. But she can't do that. You can. You can do something. Currently, as I stated, I'm still in court. They're looking to have this wrapped up, 2 more days of trial, in just a short, less than a month. This department, yet again, although they asked to back out of it, even though per the prior court order they were supposed to be an interested party for any future proceedings regarding custody visitation of this baby, they asked to back out once the caseworker gave testimony, which, before I close, I'll go over that with you real quick. It's pretty compelling. At least it should be. But you know, I've got a department that still opposes. After all this, can you believe it? You don't remain silent at best, okay? You say, let this girl go, okay? No, you continue to oppose me because of liability. So my attorney had to motion subpoena 2 more department caseworkers, supervisors, because their caseworkers are gone. As soon as this caseworker testified, she left our agency in less than 60 days. She was gone. I don't know why, but she was gone. Maybe she found a nice summer home somewhere. I don't know. She'd only been there for about 1.5 years. She'd been there less than 8 months when she took on Kendall's case. And then she was gone. She testified on September 9th, 2019. She was gone by December 1. Needless to say, in order to get the permanency hearing report in as evidence, in case of an appeal, because boy, let me tell you, this was certainly looking like another $70,000 ready to get dumped on an appeal. What does Christopher Stevens on behalf of the Department of Social Services do? How do they respond? He filed a motion to quash the subpoena. Caseworkers already testified. This is utterly irrelevant to the current matter pending for custody. Tell you what I'm asking you. Number one, what I'm asking is that my commissioner, as head of that agency, immediately have that attorney withdraw that motion to quash. When does this end? Are we going to keep this up? I'm preparing an official complaint to the New York State Inspector General's office. That is where it's to be directed for malice or negligence at the state level for a human services agency in New York State. I'm not threatening. I'm telling you I'm tired. There's a little girl that has a family that she is connected with, whom she loves, who she is being kept from because of the influence of the Department of Social Services. And I can say with 100% surety, I would not be here tonight. I would not be keeping you from your dinner. Had Jennifer Constance been contacted right from the beginning, like SOP and SLP in your manuals and your court orders and your administrative directives, I would not be here tonight. Kendall has a room in my home. I have court-ordered visitation because it's still pending, but I'm being told this referee, who is in charge of deciding my trial, will not see the county get brought down. And at this point, the child's been with the woman long enough. Really? The child never should have been with this woman. I was entitled. I was an intervener. I was an interested party. I was the one, as a grandparent, exclusively a protected class in regards to notification and interception into intervening in an Article 10 neglect case. There is no other way about this. The department pushed on, pushed up hard, and just kept going. So when I did try to come in after the fact and file the appropriate motions, the appropriate paperwork, opposition, opposition, opposition. That's all I've gotten. That's all I've gotten. So on one hand, you say there's nothing you can do for me. But on the other hand, you come back behind me and you still try to put me down. That doesn't make any sense. Makes no sense whatsoever. Are you trying to provoke me? Could you not at least have done the honorable thing? I understand maybe you were concerned about the liability, okay? But honestly, do we need to do this? I've got a boatload of people whose hearts are also broke watching me go through what I've gone through for the last almost 4 years that are begging me to pick up the phone and call anybody they need to call. This needs to go public. This needs to go public. That is not what I want. I want Kendall Constance. I want the opportunity. I want the department to send a letter. Talk to Dave Paulson. I don't care how bad this looks on the department. The cat's out of the bag, folks. I need a letter from the department to the family court, to my attorney, to the respondent, Amanda Bush's attorney, that reads, after careful consideration and review of the facts and circumstances of the original petition of the Article 10, the department failed to notify, per law, the immediate relatives, specifically and exclusively the grandmother, Jennifer Constance, in which we acknowledge that she was entitled to, and that we will not object to a motion to reopen that original custody matter. I do not think that that is too much to ask at this point. It gives me a crying chance at least, because now for the CPLR, yes, am I past now the 15-month cutoff for filing a motion? Yes. However, also in the CPLR, it states that if any party entitled to notice of the original proceeding, that's Jennifer, didn't get it, but that's me, okay? I have new evidence or can show that there was fraud, mistake, or any negligence per the CPLR, a judge at his discretion may vacate the original order, may reopen the original order, or may deem an immediate change in the placement order. That's what I'm asking. That's what I'm imploring. That's what I'm going to demand. Because I cannot and will not allow Kendall Constance to continue to live a different life. She's 4 years old. She's living a different life. Grandma, Miss Amanda tells me I have to call her mom. And because I love the child, and I will not confuse the child anymore, I tell her that it is okay. But what am I supposed to tell her? You have 2 mothers, Kendall, you have 14 grandfathers and grandmothers, yes, her boyfriends, this is lunacy. The child's 4. I need to get her back into good health. I need her to get her back into her family's home. She needs to be where the law said she had the opportunity and should have been afforded the right to be. So if you want to know what was the point of me coming here, that's the point. And I am afraid. I am afraid because I've lived what, the CPS manuals and the law say. I could go on and on, guys. I have letters from administrative directors, from OCFS, the caseworkers training manuals here. Number 1, New York State Child Protective Services Manual, Chapter 9. I printed off the December 27th, 17 version for you, so that, someone doesn't come back later and say, oh, well, how do we know what that manual said back in the period of time when, this Article 10 case went down. It's right here. Specifically, F, removing a child. 1, search for placement resources. 2, notification of identified potential placement resources. B, reporting and documenting the search for the placement resources. G, hearings after filing petition for removal of a child. B, search for placement resources. H, intervention by other interested people. K, permanency hearings, notice of permanency hearings, permanency hearing report. Let's go to intervention by other interested people, because remember back what Mr. Stevens had said? Okay, number 3, intervention by interested people. If the parent consents, the child's adult sibling, grandparent, aunt, or uncle, not named as a respondent in the Article 10 petition, may intervene in the proceeding as a interested party intervener. I've all told you I'm the grandmother, right? I've all told you that, therefore, per the law, and per their own manuals, I would have been a party to the matter. Therefore, I would have been able to, request the motion to vacate, but Christopher Stevens says I wasn't a party. The intervener, i.e., a non-respondent parent, which would have been Brandon, father, or relative granted permission to intervene, has the right to participate at the fact-finding hearing and other hearings that may affect the temporary custody of the child. Interveners may also participate in all phases of the dispositional hearing. Family Court Act 1035F. I didn't give you that one. Although the court has the authority to issue and serve summonses, conduct hearings, and grant intervener status, CPS caseworkers do have a role in these decisions. Oh, here's some accountability and culpability again. Particularly with regard to intervention and its possible effect on the plan for the child. Remember that plan, the plan? Because the law advises the court to liberally grant motions for intervenor status, CPS must obtain as much information as possible related to the willingness and capability of non-respondent parents and other relatives to provide temporary and/or permanent care for the removed child. CPS is obligated to make reasonable efforts to prevent placement. Here's another law, 18 NYCRR 430.10B. And again, in their manual, OCSS, CPS must report the results of the search for placement resources to the court and all parties, including the attorney for the child. Family Court Act 1017, there it is again. CPS must also document the results of the search in the Connex Progress Notes, which is now, I believe, Connections, in the permanent case record. Documentation must include name, address, employer, social security number, any other identifying information known to the local DSS. I just want to read to you quickly, this is in your packets. Again, back to the department's response to family court in opposition to my every motion. Form 10-7E, notice to relatives and suitable persons of pending child protective proceeding in the matter of blank, family file number, case number, notice of pending child protective proceeding, relatives and suitable persons. 2, this one, for instance, was to Denise Murray, the other grandmother, Lindsay's mom. Please take notice that a child protective agency has filed a petition in this court alleging that blank neglected, abused, severely abused, or repeatedly abused a child named in the petition. Please note that you're not named as a respondent, however, because you may be a possible resource to care for the child named in this petition, you are entitled to notice of the pendency of this petition. You are also entitled to notice of certain rights and information as follows. 1, you have a right to be heard in proceedings regarding the placement, the custody, or guardianship of the child. You have a right to appear in the family court and to seek and provide care, custody, or guardianship of the child. The petition will be heard on November 29, 2017, 2:30, Family Court, 163 Arsenal. A, you may seek to be approved as a foster parent. B, you may seek to provide free care for the child to reside with you temporarily. C, you may file a petition under Article 6 of the Family Court Act seeking temporary custody or temporary guardianship. 3, you may contact the following social services official to discuss the options in paragraph 1. Jessica Gilchrist, 250 Arsenal Street, 786-7486. 4, applicable only to grandparents. You may file a petition to obtain visitation with a child under Section 1081 of the Family Court Act. But it's just a piece of paper. Oh, they didn't get their piece of paper. No, this tells you what your rights are. This is required by federal law. This is required by state law. This is required by administrative directives. And this is required and trained in your academies and in your CPS manuals and by the family court and by OCSS. Have I forgotten anyone? This is the law. This tells people like Jennifer Constance what you have the right to regarding your kin. Amanda Bush was not entitled to this. But DSS told her where to go, when to be there. They gave her copies of everything. This girl was sitting in the courtroom listening to a complete stranger's private drug, sexual, mental, and emotional history because my agency, our CPS, allowed her, told her where to be, and family court entrusted that DSS when they were telling and whatever they were putting in the reports, and we've seen what's in the reports, they had no objection to her being there. The attorney for the child didn't object to this girl being there. Why didn't anyone at any point? I don't understand. How is it with this flim-flam permanency hearing report of 2 sentences where they claim that all grandparents have been made aware, how do you deduce everything I've read to you into 2 sentences that say all grandparents have been made aware and here's the paternal aunt? And you hand the child and you ask the court, DSS petition the court, we want a change of placement. The court said, my decision to agree to that is based on your reports and your testimony. Not the parents' plan, not because the parents agree, just because of DSS reports and DSS's testimony. So I ask you again, why would a family court, after all of this, not take them seriously? Because that's what they do every day. That's their job. That's their responsibility. That's the weight that they have over me, my grandbaby, your grandchildren. God forbid one of you ever have a family member, because it can happen to anyone. I didn't ever think it would happen to me. My son, right into the opiate crisis. Probably still there. The last thing I'm going to go over with you is what Jessica Gilchrist was asked and what her answers were and when that occurred. Jessica Gilchrist, CPS worker, took the stand after being subpoenaed, a judicial subpoena, by the way. My attorney tried to do a regular subpoena. What do you think the department did? You think they said, okay, no problem. We'll have Jessica there. It's a subpoena. Nope. Refused. It cost me $500 more, with 4 more letters going back and forth, and a request to the referee to request a judicial subpoena. Finally, my department agreed to produce the witness. The other subpoena that the department was given, again, that they declined and refused, was they were asked to provide any and all records in their case records to show any and all contact with Jennifer Constance, including emails, letters, phone messages, notices, anything. Refused that subpoena too. Once again, Jennifer had to pay $500 more so she could get a judicial subpoena signed by the bench. Bench signs it. Finally, they have to comply. Do you know what got produced? Exactly what you hear. Nothing. Because it never happened. Then the caseworker has to take the stand under oath. She's sworn in. On September 9, 2019, she was asked and answered the following questions. Were you the primary caseworker that handled Kendall Constance's case while she was in DSS's custody from September 26, 2017 through June 21, 2018? Jessica answered, yes. Are you aware that you as the caseworker and your agency were required by law to notify, with emphasis, all grandparents of Kendall's placement in foster care? Jessica answered, yes. Were you aware that Jennifer Constance was grandmother to Kendall Constance? Jessica answered, yes. Did you make any attempt by any means to notify Jennifer or contact Jennifer at any time throughout the course of Kendall's placement? Jessica answered, no, I did not. Were you fully trained and understood the procedures for notification and conducting an investigation to contact Kendall's relatives and explain to them their rights to be a part of the proceedings? Jessica answered, yes, I was fully trained and aware. She was given a copy of the permanency hearing report on the stand dated March 27, 2018, and she was asked, did you author this report? Jessica answered, yes. Are you familiar with the information that was written and prepared in this report? She replied, yes. Did you write in your report that all, with emphasis, grandparents were made aware of Kendall's placement? She answered, yes. But you acknowledge that you nor any other DSS caseworker had in fact contacted or attempted to contact Jennifer Constance, is that correct? She answered, yes. Were you aware that Jennifer worked at DSS? She answered, yes, I was aware. Did you write in your report that Amanda Bush was the paternal aunt to the child Kendall in 3 instances and in every instance in which she was referenced? Jessica answered, yes. Was Amanda Bush Kendall Constance's aunt, yes or no? She answered no. You admit under oath that you submitted a report to this court that falsely stated that Amanda Bush was the child's aunt, represented that she was the interested relative, and that all grandparents had been made aware of Kendall's placement. Is that correct? Jessica answered yes. She was last asked, why? Jessica had a 4-word response. She looked over at Chris Stevens. She looked back at my attorney and she said, it was an oversight. It truthfully comes down to, in Kendall Constance's case, that there were 2 parents who had drug issues. One was known to them, meaning the mom, prior history with DSS and children and removals, and the court, and had been here before. There was a resource that presented herself early on, and simply put, there was no one there to oppose it. It was then a foregone conclusion that Kendall was going to Amanda Bush, and no one was there to challenge her appropriateness, her right to be there. I went to the courts, I hired a private attorney, and at enormous expense, and I immersed myself in research and engaged with my son and Kendall's mother and her family. The damage has been done now. It was time to duck out for DSS. It didn't matter that the order of custody held that DSS and the attorney for the child be interested parties. DSS wanted out to once again interject in an attempt to stop our request for information. We again faced opposition. DSS again filed a motion to quash, still pending. My commissioner responded to me quite some time ago in an email in regards to my heartfelt plea for her assistance as the department head. I had that email, as you know, and I've often thought about that response. It was disappointing, but not completely unexpected. I'm sure that Teresa was in a position that she was advised never to admit or concede to wrongdoing on behalf of the department. But I held out hope that on a professional level, she would decide to do the right thing, no matter the cost. The honest thing. Acting with integrity. And quite possibly maybe a little accountability if necessary. But integrity above all. Because when my county approves my salary, and I am salary of course because I am management, there's an expectation there, is there not? Integrity. Above all. What are we if we don't have integrity? What are we? Maybe you need more training, maybe you need more experience, that's fine. But whatever level, and with that expectation, there should be integrity in how you do your job on a daily basis. And if someone underneath me and my staff has done something incompetent, my commissioner has the right, and I would expect, would call me in and say, listen, that's a problem, it was wrong, it was against the laws, it was against our agency policies, it was against our administrative directives, it was in violation and contempt of the court order. John Stavick wasn't like that very much. I hear a lot about that from him. Oh, contempt of the court order, you can't be out of compliance with a court order. Well, how many court orders was my department out of compliance with? Now, come on. Let's keep it real, because it is real. I'm living it. You all get to go home. You might get to see your kids, or your grandkids, or your nieces, or your nephews. Pretty much you can pick up the phone and see them. I cannot. Not one single allegation, not even an allegation has been lodged against Jennifer Constance through almost 4 years, and trust me, if there was anything, I'm quite sure it would have been used at this point. There is no reason, there's not even an allegation as to why I am not the most fit and appropriate and only relative that has been involved in Kendall's situation since I inserted myself after being excluded by the responsible authoritative agency. And I want Kendall back where she belongs, and so do they, and so does the mother, and so does the father. They testified in court, in surrogate's court. They signed extrajudicial consent for me to adopt Kendall. The only person blocking it is Amanda Bush. The only person that Amanda Bush was even allowed into this, insert herself into this situation, it was by one engine, and one engine only, the Department of Social Services. She did not have the right to intervene. The law says so. You know it. I've read it to you, and it needs to be fixed. I'll tell you that as a believer in the services that our agency provides and a believer in so many of the employees that I have witnessed work in good faith with consciousness of the consequence of their daily actions upon families and individuals, I respect the position of the Commissioner's office, but I've lost my faith in the management of the mission in that statement. The only thing I'll ask back would be the picture of Kendall. But I would ask, if you wouldn't mind, if you would please take a look at least at the picture of Kendall before you leave tonight, because I'm going to stay. I think there's some other people that have some things to say. Thank you for your time.
Thank you, Jen. If there's anybody else who'd like to come up.
Good evening. My name's Julia Gosher, and I would like to tell you a little bit about a new organization which I'm very proud to be a member of the board. With me tonight also is our executive director, Wendy O'Donnell, and our counsel, Seth Buckman. This organization is just starting out. We are in the process of getting our 501c3 and all the other things that go along with it. We are in the process of finding a home for our organization. The purpose of the organization, which we call WARM, it stands for Watertown Area Rescue Mission. The purpose of WARM is to provide a warm, safe environment for the homeless in our community, specifically in the cold months of the year. Nobody should have to suffer from cold or hunger. The purpose of our organization is to make sure that there is shelter for these people. Unfortunately, in the Watertown area, we have a lot of homeless people. They're homeless for quite a variety of reasons. The reasons aren't the problem. The problem is they're homeless, they're cold, they're hungry, and they're seeking warmth and refuge in places where they don't belong. It's a problem for the whole community. We are making effort to take steps to help solve this problem. Now, the Watertown Area Rescue Mission will not be a hostel. It's what's called a warming station. By being a warming station rather than a hostel, we are able to welcome anybody who needs our help. We don't have to go through government channels to vet them or to decide whether they fit into the category. We can help anyone who needs our help. We are working on finding a location which is suitable for this purpose. We expect to be able to take them in specifically from probably 8 o'clock at night till 8 o'clock in the morning, something along those lines, to provide food for them, to provide a place for them to take showers, to feel safe, to feel warm, to feel welcome, and to feel that they are not imposing on the community. It's a very big venture, but in my opinion, it's going very, very well. We have been very well accepted and encouraged by many organizations in Jefferson County, organizations such as the Salvation Army, many of the churches, even many of the businesses have expressed an interest in helping us in any way they can. We feel that this is a very cost-effective thing to do for the county also. It's certainly much cheaper than housing them in motels, and it's certainly much safer. We hope to be able not only to provide them with a warm place to rest, with a warm meal, but also with the channel, the information they might need to get whatever kind of services might help them, whether it be mental health services, addiction services, physical health problems, or many of them, it may be just a matter of meeting people who can give them a little hope. We all in our organization either are people who have suffered homelessness or loss due to drug addiction or other kinds of tragedies. Either we have suffered these things ourselves or we love someone, we love someone who has suffered these losses or is suffering now. We want nothing more than to be able to do our part to help others. We will be giving you more information in the future. Right now, we are in the formative stages. We are very hopeful that by the cold months next fall, that we will be open. If we can save one life lead one person from personal failure to personal success, give one person hope. It's worth everything we're doing. And we sincerely hope that as we come to you in the future with more specific needs, that you will be able to help us. Thank you.
Thank you.
Hi, I'm Denise Murray, and Kendall is my granddaughter. And I just wanted to let you know that we have missed out on so much with Kendall because of things being blocked. When Kendall was taken, I specifically told, I did not know anything about Jennifer except for Jennifer, her name. She worked at DSS. The caseworker asked me, do you know anybody on his family? I said, I know his mother's name is Jennifer, she works at DSS. The caseworker said, I will look into it. She was more concerned about me getting information on Lindsay's father that lives in Wisconsin. I said, I don't know anything about him. I said, can you look into Jennifer? She said, we'll look into it. She did give me updates down the line. I would ask her, have you gotten contact? Is there anything that Jennifer can do? We're still working on it. Again, I think because of this, Kendall's almost 4 now. We're missing holidays. We're missing her school things. We're missing so much because it's been blocked from our family. Jennifer only gets 2 phone calls a month that she gets to talk to Kendall. Her sisters only get to see her through Jennifer, and they love her. They have a very, very strong bond when we do get together. We try to celebrate holidays together, and the other party will not acknowledge the sisters, which is very hurtful, and it's very hurtful to Kendall, because she has to tell us, those are my sisters, right? And I don't entertain it because I'm not going to confuse a little 4-year-old. But it's confusing to me how we even got to this, why we're even standing here fighting for a granddaughter that's with somebody that's not even family, that something should have happened in the very beginning. It fell on deaf ears, that we were trying to keep her with family, and they shut me right down. Like I said, they're more concerned about somebody living in Wisconsin than they wanted to hear about Jennifer. And I told them, I said, you know she works it, we're working on it. So I will pray for everybody in this room that they never have to fight to see a beautiful little girl that is totally innocent in this, and she can't make decisions. I want to see my sister. I want to call my sister. I want to see my grandma, because it's blocked. There's a court order saying we cannot contact her. So please help us get our granddaughter back. That's all I'm asking. Thank you so much.
Thank you.
Hi, I'm Vicki Catino, and Jen's mom, Brandon's grandma, and Kendall's great-grandma. And I really thank you for the opportunity to come and tonight that Jen could share this battle, this crazy battle. You know, in Pennsylvania, where I live, I'm also a kinship parent. My husband and I, we took on grandchildren, okay, because of the opiate crisis. Our son got into it, and the mother of the grandbaby, and we went through this process. And I have to tell you, you know, I have always been a part of Jen's life. We're a close family, and when this was happening with Kendall and this battle, I came up to be here, to be a part of it, as much as I was allowed to be, to sit in the courtroom until they did no longer allow us to do that. But in the very beginning, I could not believe what I was seeing with my eyes. I mean, just the fact that someone who was a stranger, okay, to this baby, when the grandmother wanted the baby and Jen was being kept, it was just mind-blowing to me. But really what got to me more than anything else, having been a foster parent, we were vetted for weeks. Weeks. We raised our own kids. We didn't have any problems. And what we had to go through, the classes, the checking out, the background checks, everything that was involved before we would be able to be accepted to have our grandkids under the kinship program. And I came up here and watched what was going on in that courtroom. I couldn't believe my eyes. I mean, you just didn't, you go home thinking, what in the world did I just see? What's happening? And the ironic part is, my daughter works for that same agency. And, it broke my heart when I talked to her because she tried to encourage her through this whole thing. And every time, she put a foot forward, she'd meet the resistance. And, it wears you down after a while. But you can see from the paperwork in front of you, the countless hours that she has put into the research of the law, which is what we are all supposed to abide by. I know we did in Pennsylvania. We had to abide by the law in order to get our grandchildren. But I watched the countless hours that the families put into the research, the heartbreak that went on every time you were rejected, and things that were being said that weren't true, and how they covered up each other's stories. It was a circus. And I'm sorry, but I certainly trying to tell you from a heartfelt position what I witnessed. And I went home thinking, how is it possible that this baby is being placed, and they are covering up what they did when they checked out, or were supposed to check out, where she was being placed. And then when a real parent, or grandparent, came forward and was willing to open up her home and take her in, okay, they found fault with that, and they made all kinds of reasons and excuses. So I'm just here to say, please, take serious what she's put in front of you. Look at it and see what we all witnessed, and then make your decisions. Because Kendall is a blessing, and we all want to be a part of her life. She can't come and see us. We have to come up here to see her, and we have to do that on that visit that Jen gets. But do you know, if Jen hadn't done the fight that she's put into this, she wouldn't have the time she has with Kendall right now. But she wouldn't relent. But I'll tell you, another thing that was so hard to deal with, but what I try to encourage her would be, Mom, the job that I love, the job that I've been doing all these years, the very place that I serve, it hurts me to go to work now. I'm so disappointed. I am so disappointed. I'll tell you something, that's not Jen. She wouldn't be part of that compromise. That's not who she is. And I'm so very proud of her. Thank you for taking the time tonight, but I'm telling you, I am so proud as a mom to listen to what she's done and how she's put it together for you to try to bring you into what she's been experiencing. The whole family has, actually. And all the friends and the support from the workers as well. And all of them. They've been such a blessing. But just please, I agree with Denise. Take it to heart, look at it, check it out. See if what she's presented isn't exactly the truth, and then make your decision, and please do something about it, because this isn't right. Okay, have a good week.
Hi, I'm Eric Porter, Advocacy, Massey Street in Watertown. It's been a while since I've been to one of these things, so you'll have to excuse me. First and foremost, I do want to thank you for the unwavering support that some of you, most of you, have shown our family over the past several months. It hasn't gone unnoticed, it hasn't gone unappreciated, and we are forever grateful for your guys' help. Your support in the resolution that was passed in favor of our family as a foster and adoptive home joins the endless community support we've received, as well as the support we've always had from our friends, our co-workers, our family. Unfortunately, it seems that your resolution was ignored by the agencies that were meant to receive it. St. Lawrence County DFS continues to poison their county, our county, and those surrounding with shameful misconduct, administrative failures, and personnel complaints. Additionally, there's been no action by CHJC to right their wrong in decertifying us as a foster home. In fact, we've experienced quite the opposite. Children's Home has dug their heels in and continued to spew a false narrative about our family. Their administration continues to actively work against us, refusing to speak to agencies or provide any information or any documentation to agencies like Clinton County DSS, who are really gung-ho about trying to certify us as a foster and adoptive home. However, Children's Home had no problem after they wouldn't talk to Clinton County, absolutely defaming us to Jefferson County DSS, telling them that the Children's Home would not ever recommend our home to reopen. On what grounds? We've never been convicted of any crimes. I've had 2 speeding tickets. Be forthright with that. I mean, we passed all of our background checks at the local level, state level, the federal level. We have outstanding reputations in the community. Most of you know we're both teachers. We have no record of harm or neglect against any child in our care, in our classrooms, or elsewhere. Caseworkers have pined over working with our family. One even told me, administration told me you were one of the best foster parents they'd ever seen, but that's before you questioned them. If there were really concerns about our parenting and the safety of children living in our home, we wouldn't be allowed to continue raising our biological child. He just turned 3, by the way, and he loves to point at pictures on our wall of our now former foster children, and he asks, "Mommy, when are they coming home to play?" What's more, Children's Home has forbidden caseworkers and other providers from speaking to me in any capacity. As the Jefferson County representative of child, my job is to provide advocacy, support, and education to families while helping to hold agencies accountable when decisions are made that are contrary to a child or a family's best interest. Sadly, most of these families are involved with Children's Home in some capacity. There are caseworkers and other service providers that work for Children's Home who recognize the rampant misconduct, favoritism, and lack of integrity, sometimes especially at the highest levels. One provider for Children's Home told me that administration forbade her from talking to me, a support provider for the family. The reason? Not only did CHJC say that my own family was trustworthy, but Children's Home claimed that Child was an organization that was suing CHJC. These baseless claims are just simply not supported by fact anywhere. They are lies intended to alienate both foster and biological families from seeking help when they recognize mismanagement in their cases. An agency that's supposed to support these families is actively preventing them from seeking help from an unbiased organization that has made a difference for countless families. Despite some workers from Children's Home telling me they were risking their jobs with the agency by talking to me, I've spoken to quite a few of them. I'm shocked for them, and I promised them that I would give them a voice. I'd like to bring you some of their concerns today and urge you to review any contracts you have with this agency, as well as investigate this extraordinary misbehavior if possible prior to providing them any more considerable funding. The concerns of present and former workers of Children's Home include the following: staff being discouraged from giving accurate information to the Justice Center when the Justice Center was completing an investigation, refusing to give time off or compensation to workers who were injured on the job, making employees use their personal automobile insurance to pay for damages to vehicles owned by CHJC that were damaged by no fault of the workers, like this one lady who was rear-ended out here on Public Square by another driver, improperly blocking fire exits so children could not leave when there were community members on campus at the direction of administration. Many staff sexually abusing the teenage youth involved in the program. Why did this never make the news? One staff member was charged with rape and wasn't even immediately fired. He was allowed to use his sick time and his personal time off before he was let go. Medicaid fraud. This came up in every single conversation I had with every single employee that I talked to. Duplication of services, so CHJC can bill Medicaid and foster care for similar services. They also had direct care staff administering medication without training and without licensing. There are staff that have been written up 20 to 30 times that still work for the agency. This is a good one. This is a recent one. Making foster parents sign agreements that they will be financially responsible for the medical or dental care of a child if they fail to get the child an appointment within 30 days of placement. Appointments which local DSS is responsible for and should be setting up when a child enters care. I'd be here for the next 3 hours if I brought forward all the concerns raised by workers, but I know we all have families we want to get home to. So, speaking of families, mine isn't any closer to being back together than it was when I spoke to you at Christmas time. I was so thankful when at the highest level, Jefferson County DSS administration said they would sign off on approving our family to be a foster home again. We were like, this is it. We're finally going to get our kids home. We were hopeful that Jefferson County DSS was finally going to right the wrongs, take the first step towards fixing the irreparable harm that they participated in when they agreed with St. Lawrence County to remove our foster children from our home with no evidence that my husband or I had ever abused or neglected any child in our care. Instead, after we jumped through all the hoops, we did all the safety inspections. We had all our paperwork in within 24 hours. I think that might be a record. DSS went back on their word. They refused to certify us as a foster home. They even refused to accept us as a kinship foster home, despite our children's biological parents asking for us to be certified as a kinship home in compliance with the Family First Act, a federal law. You've heard about Family Court Act 1017 already tonight. Kinship should be a legitimate option second only to their natural family. Kinship includes all relatives and other suitable known adults. Despite us giving Jefferson County these 52 letters of recommendation supporting our family, as well as the letter and resolution signed by you, and this letter from Mark Walvick supporting us. These are all in support of our family. Jefferson County DSS still refused to certify us after all that. Despite that perfect safety inspection, passing all the background checks, getting everything done we needed to, probably the fastest that anybody has ever done it, they still refused. While DSS, both here in Jefferson and out in St. Lawrence County, stick with their absurd goal of keeping 4 siblings from being adopted by our loving and very capable home, so many other children are falling through the cracks. While DSS focuses all their effort on preventing us from being a legitimate resource for vulnerable children, they're neglecting to investigate real instances of abuse, some that are occurring in their own certified foster homes. There are foster children being presented for visits with their biological family members with bruises in the shape of handprints all over their bodies. There are children being diagnosed with PTSD and other new behavioral problems resulting from the trauma that they have experienced in Jefferson County foster homes. There are small children, some that are toddlers, with suspicious bone breaks, unexplained or even sometimes unnoticed by their caretakers, and uninvestigated by DSS. And on the off chance that there is an investigation, their cases are quickly opened and shut when it involves one of DSS's own. At what point will DSS be held accountable for the children they're letting be abused while they focus all of their effort, all of their energy on preventing perfectly capable and willing parents like us from being certified? And I know what most of us are thinking. I hear it all the time. Everyone's so quick to say the system's broken. Yes, the system is broken. Absolutely. Speaking broadly, most systems that are broken are in need of change, not more of the same. This change requires efforts on all parts involved. In terms of the social services system, that would involve the local DSS, the voluntary agencies like Children's Home, the lawmakers, the constituents, and the oversight such as OCFS. But if not all of those people, especially those at the very top, are interested in implementing change to better the system, it's not possible to fix what's broken. I believe the constituents are ready for change. I'd like to think that lawmakers know it's necessary. It seems that DSS itself even knows that change must come. But is anyone lining up to fix this system? In my experience, and in the experience of many people here tonight, it seems like DSS, CHJC, and OCFS are perpetuating this horrible problem. The system's broken. My ultimate goal is to fix this system. Change has to happen, whether it's in my lifetime, whether it's in my kid's lifetime. It has to happen. At Child, we have some ideas for immediate fixes that should be implemented here at the local level. DSS simply needs to follow the law. Obviously, as you've heard tonight, it's not always happening. It's just not happening. There need to be more open lines of communication between DSS, the rest of the county, the legislators, including the constituents who just see a silver lining. That 60-day deadline I talked about for CPS investigations needs to be heavily enforced. There are cases going upwards of 6 or 7 months without resolution. Sometimes those cases end up being indicated, which means that for 6 or 7 months, these investigations were open, there was some credible evidence of abuse or neglect in the home, and nobody did anything about it for that long. Over 60% of reports here in Jefferson County are closed after 60 days. 60%. I've read the manual as a worker. Preventative services should be utilized in each situation they're applicable to. An Article 10 neglect petition in placing children in foster care should not serve as a one-size-fits-all. It shouldn't be the solution, always, in terms of abuse or neglect. There need to be more services, and I believe there are services in our area, but nobody is utilizing them, or the people that are in charge of referring out aren't doing that. Kinship needs to be looked at as a legitimate option, and federal law dictates compliance with it. Community outreach should be looked at, completely scrapped, overhauled, and better utilized here, so vulnerable populations are aware of the services that are available to them, especially in crisis situations like domestic violence. There need to be policies and procedures in place to prevent the children in foster care from being monetized. This is important. Children should not be in the system so they can turn a profit. Reunification should be the ultimate goal, and there's no excuse for kids sitting in foster care for 4, 5, 6+ years. No excuse. Until everyone can get on the same page and changing the system, nothing's going to happen. This cycle will continue. Kids will keep going into foster care. They'll keep growing up, having more kids that sometimes enter foster care as well, because those with power do nothing to change the broken system. As a Jefferson County representative for Child, I'm still collecting complaints from individuals that have experienced misconduct or case mismanagement at the hands of Jefferson County DSS and CHJC. I would encourage anyone that has a complaint or knows someone who does to contact me. My email is childhelp.jefferson@gmail.com. I think I can help. And as always, thank you for your time. When you leave tonight, please give your children an extra hug before you tuck them into bed. It's something I've been waiting 8 months to do with our kids, and that's 8 months with no end in sight. Thank you.
Thank you. Is there anybody else that would like to speak in front of the board?
Hello, my name is Alicia Woodworth. I live in Watertown, New York on Jacobs Road. Back in 2019, I tried to get help for my daughter Cheyenne by reaching out to her child coordinator with CHJC. Her child coordinator is amazing, but she ended up turning it into CPS because her supervisor told her to, so she wouldn't lose her job. CPS ended up turning it into a case against our family, and then a month later, October 28, 2019, they took all 4 of my kids away. They spent over 2.5 years in foster care and were bounced around from home to home. It was about 70 homes. Our cousin had our youngest 2 boys, but our boys were being abused by them. And when our cousins gave them up, finally they were allowed to live with their grandmother. All 3 boys went to live with her at the same time. But their grandmother had to go through so much to get them. Grandma had them for about a year, but then CPS took my boys away from her, too, when my youngest had a scratch on his face. The caseworker it was originally from DSS, said that her supervisor made her call CPS about the tiny scratch, just to get my kids out of their grandmother's home. The caseworker thought the kids were safe there, and they were. Then CPS came to the grandmother's house and further traumatized them. CPS blamed it on the children's home. Then, because of the scratch, my children were taken away from their grandmother where they were safe. Then that night, CPS told my kids and us the kids were only leaving for the weekend and that they would be coming back after the weekend. My youngest son wanted to run away because he was so upset. CPS didn't even have car seats for my children when they wanted to take them. Their grandmother ended up letting CPS take her car seat. She never even got them back from CPS. CPS put them in a foster home that was certified by CPS. My youngest son had fingerprints all over his body, and I do have pictures. They were from the foster mom. His therapist thinks he has PTSD from being abused in that home. I showed these pictures to DSS and nothing was done at all to protect my kids. They actually made us send the boys back to this home after showing them the bruises. They said if we didn't send the boys back, they were going to take away our visits. Isaac has such bad PTSD now that he is traumatized and is having tantrums and doesn't know how to deal with his emotions. But everyone else worked against us, and our caseworker from DSS tried to terminate our rights, even though our kids were safe at home. They were getting all of their information from the foster parent that had my daughter, Cheyenne, and it was all lies. Also, Cheyenne's foster parents was related to one of the supervisors at CPS, which is how she was always able to contact the caseworker. And they also ended up taking her side. If DSS and CPS doing this to us, how many other families are they doing this to? We are traumatized from this, and so are our kids. If you want to hear more, you can call me at any time, and my number is 315-816-6228. These are actually the pictures of my son from the last foster home that he was in Jefferson County. And these 2 pictures right here are how my kids were a year before they were taken. They're not like this anymore. They fight, they argue, they beat on each other, and it's ridiculous. It's just crazy what CPS and DSF get away with it. So I'm hoping by being here today and telling some of my stories, you guys may be able to help. Thank you.
My name's Liz Doherty, and I did speak here one time, about 8 years ago. And we, as a collective department, wanted to make sure that when we were hiring a new commissioner, that things were going to change. I will tell you, I know Jennifer. I do know Erica. And since I left and retired from here, some of the biggest issues I have spoken with some of the legislators about, and that's considering how many people have come through the doors to work as caseworkers and have walked out the door, some as many as 4 hours after being hired. I think that that's something that you, as a legislative group, need to look into and say, why are people being hired? And why are people being fired or walking out within a year or within 4 hours? My question is, why don't you, when people send you emails, respond by saying, we're going to look into this? My own legislator did. I hope he's still looking into it. I have talked to many people who have the same complaints. I started with a group of people way back when Mr. St. Croix was on this board. And I think some of you remember him. Long gone, but you know what? He really wanted to do something, but he thought the union should do it first. He was a union man. So when we asked for somebody to be hired as a commissioner, we asked, and everything came out as, the union is trying to make it be so that our own workers aren't hired as a commissioner. I can say that now that I've been retired 6 years, that wasn't the plan. The plan was we wanted the best commissioner after giving us 2 commissioners that failed this county miserably. I can go through it for hours, but I think we'll get the point with my voice. In listening to Jennifer, I'm sure that they caught my face on camera going, oh my God, no, that shouldn't have happened, because I was a CPS caseworker until I took leave for sick leave. And one of our commissioners said, it didn't take me that long to heal, so you're going to another unit. Fine. Mr. Paulson, I think you now have to look into fraud. If somebody signs a paper in a document that goes to court and says, this is true, and they lie, that's fraud. And it goes all the way up. The caseworker, the supervisors, the senior workers, the commissioner. The commissioner has somebody in that office that reads the cases after they have been submitted to the state, and they can't change a word in it. What a waste of frickin' time. If I go out and I do a case, and I have questions, I have a senior worker, I have a supervisor. The supervisor has a supervisor, and the supervisor's got the legal department, and the legal department's got the commissioner. One of the ladies that left here tonight, I assisted. I'll admit it, I don't care. When she was found guilty, okay, her case was indicated. She hired an attorney that I suggested. We worked together, and when she had her fair hearing, the judge online said,
Who made the decision? The lawyers told us who made the decision to indicate the case. The judge said, get her. 15 minutes you've got. Get her. Lawyer went down, and this person said, I'm not talking to no judge. I'm not telling them why I decided that. Lawyer came up and said, we've got a problem. Judge said, what's the problem here? She's not going to display herself to you, Judge. She doesn't want to talk. He goes, then you know where the decision is going. Because I wanted to hear from that person in management why they wanted this case indicated. There are problems in CPS. There's problems in the other units. The people are coming in, the people are going out, and you're wasting a hell of a lot of money in this county training these people, because it takes 2 years at least to make a damn good caseworker. Was I put on the line? Several times. I think a couple of you at this table know that. Okay? I did not care. Because it's the families in Jefferson County that I cared about. I didn't care about my title. I didn't really care about the commissioner or her people up there. And I would fight my supervisors. I might have been on an island by myself. But you know what? When our families are taken over by CPS in their own home, they're on an island all by themselves too. And if we don't have workers that can go in there impartially and say, there is abuse or there's not abuse, we have ruined a system that is made here to protect children. I would suggest to Jennifer, personally, lawsuits, because that's fraud. That's one of the first papers that you're given when you're taking a child out of a home, is a grandparent's right letter. And if you don't have that filled out and written in your notes, it never happened. Therefore, that whole case is fraudulent. And I think the Attorney General for the United States, maybe even, should be called on this, because it is law. And Jennifer quoted each law correctly. Every one of them. Personally, I think you need an investigation on all signatures on that case. Because that case should be thrown out and restarted. That child is owed a grandparent. And it needs to be done, not tomorrow, tonight.
Thank you.
Good evening. My name is Courtney Fantona. I'm the founder and director of Community Helping Individuals Living in Distress. Although you may not be familiar with me, you're certainly aware of my colleague, Eric Porter. I would like to start by thanking you for welcoming me to this meeting and allowing me to speak to you tonight. While I am not a citizen of Jefferson County, but St. Lawrence County, I have been contacted by many of your constituents with complaints about your child welfare system. These complaints and concerns are serious and can no longer be swept under the rug. These individuals include biological parents, such as the Woodworths, foster parents, such as Jameson and Erica Porter, and also grandparents, such as Jennifer. We've also heard from both current and former agency employees. While in comparison, your issues in this county are not as severe as those in St. Lawrence County, if not addressed soon, they have the potential to be extremely catastrophic. While we hear many complaints about Jefferson County DSS, a large portion of our complaints are about CHJC. These concerns are further solidified by employee reviews of this agency. These public reviews speak volumes about the leadership that you have hired to care for your children. In the fall of 2021, I was approached by CHJC Director of Children's Services, Victoria Peck. Victoria, whom I knew previously, stated that herself and the then director, Karen Richmond, wanted to learn more about our organization and to see if there was anything that they could do to assist with our concerns. I welcomed this meeting and a date was set for November. However, this meeting was ultimately canceled by CHJC and never rescheduled, despite requests from my organization. I again extend this invitation to sit down with CHJC management because I do have questions, and I welcome the opportunity to have this conversation. Unfortunately, my expectations are not very high. As Erica has mentioned, our team has been contacted by several employees who have stated that CHJC upper management have warned them not to speak with my organization or anyone affiliated with us. Despite the fact that my organization can offer advocacy and assistance to those families in need. What is the purpose of this? Why, if there's services available to help a child or a family, would we not want to utilize this? Ms. Peck once told me that she strongly urges foster parents to, quote, exercise their rights when it comes to advocating for their foster homes. However, it's my personal observation that CHJC does not share in this opinion. And it seems that foster parents, including the Porters, are often penalized for doing just that. Ultimately, the case of the Porters is not unlike many that I've seen in my role as an advocate. The same can be said about Jennifer's case as a grandparent. Rules are not followed. We don't hear from a lot of these families because retaliation is a legitimate fear, and there's not many families as strong as the Porters to speak out about it. For some time now, I've watched how you, the legislators of this county, are handling your concerns, and I applaud you. More counties should take note and learn from your example. However, that also means that you have the power to hold these agencies accountable. These concerns are serious. Therefore, I ask that you treat them with the utmost seriousness. You, as the representative of Jefferson County, hold the power to right many of these wrongs. These issues, which my organization hears about on a daily basis. Please feel free to reach out to me directly if I can help in any way. My email is childhealth.director@gmail.com. We all have an obligation to these children, regardless of what county we're from. These children need us to work together for their best interests. I don't know how we got here, but we can certainly do better than this. Thank you.
Good evening. My name is Casey Pickens. I'm a senior investigator with the Child Support Enforcement Unit. One of our coworkers, Regina Ryder, is actually out sick today. She wanted to be here. So I actually have a letter from her that she wanted me to read you. My name is Regina Ryder. I've been employed with DSS since March of 2011 and a support investigator since May of 2015. There are so many things I would love to say, but at the end of the day, it is quite simply put. I wish I had the patience, strength, and class that Jen Constance has shown over the last couple of years. This is her employer, people that she has worked with and loyal to for decades, and this is how it is done. Every party to this knows the wrong has been done, and instead of making it right, it continues to be perpetrated by an almost cover-up mentality. A mistake by the county that has been admitted in court, and yet her granddaughter is still not in her full custody. Jen has fought for years now to have her, and yet every county employee, no matter what department you work in, knows the main goal to keep families together. Or is that only unless there is a mistake made? To me, any person with common sense and pure thought can see how to right this wrong, but also to look deeper and question what is really going on. A good, stable home with blood relatives is open, and yet nothing changes. These are people she has worked alongside for decades, and they don't have her back when their own may be on the line. Even if it was a simple clerical error that was never caught along the many lines it needed to go through before court, we as a county cannot allow this wrong to continue. I could go on and on over this subject because it opens so many more questions, such as how many times has this happened before? and that person doesn't have the education or financial means, how does someone with a 4-year degree and a test make them capable to decide where a child should be placed and who is family? Where is the oversight? Where is the review before it even gets this far? But as I said at the beginning, I only wish I had the patience, strength, and class Jen has shown through this fight. She never once showed disloyalty to this county through this whole struggle to right this wrong. And there is no mistake, this is a wrong to Jen and to that little girl. Thanks.
Good evening. I'd like to start by thanking all of you for taking time away from your families to be here and listening to us. I hope that one day soon my wife and I can go home and our kids will be there and our family will be full.
If you would just state your name for the record.
My name is James Ford. Thank you. My wife Erica, as you heard earlier, she can stand up here and report to you the facts and figures, policies and procedures, dates and times of what's happened to our families since last August. I can tell you what I've seen it do to her. The trauma she's experienced is not like what many local families have experienced. Since we met 5 years ago, I thought that I had gotten to know her pretty well. From the beginning, I knew that she was an excellent educator. It was easy to see how much she cares for her students and creates open lines of communications with parents, celebrating their children's successes and working through their struggles. I soon saw her become a great mother and a bonus mom to all the foster kids we welcomed into our home. Like a fish to water, she was in her element. Let me share with you what I've learned in the past 8 months. Her dedication is unparalleled. It could take all evening after her full day of teaching and well into the night for her to compile and organize all the information from the people in our community reaching out to her while she works her child. Her level of empathy is unmatched. It is easy to see how much she truly cares, not just for our family, but for others in our community. Her resolve is unwavering. Erica doesn't get paid for what she does. No one in child is compensated in any way for all the advocacy they provide for people in the community. They do it out of the kindness in their own hearts. They recognize a need in the community that isn't being filled by these agencies that are supposed to be doing that work. The agencies that are supposed to be doing that work, but instead let children and families in need fall through the cracks every day. That's the kind of administration we need as social services here in Jefferson County. Someone who is willing to put in the hours, the work, to do the hard stuff without complaining, and to keep their word. I'm not saying that people at DSS have an easy job. I'm not saying they get paid enough for the work they do. I'm saying there's people here in this room that have the right attitude to provide services and advocacy to make our community a better place to live, to change the world that my son needs to live in, that all of our children will inherit. And those are the kinds of people we need at DSS and CHJC. There are some there, absolutely, but there's a lot of workers and administration in both places that need to be weeded out and replaced with people who have the resolve to put in the work and have enough integrity to always do the right thing. Jefferson County DSS informed us of their approval to recertify our family, giving us hope that our kids would be coming home. Only then to send us a letter of their refusal, after a home study that found no issues. I have seen these agencies for months dig their heels in to save face, and sadly, I don't think they're done doing that. Through Child, Erica can give a voice to your constituents that don't have one. She has the voice, but she needs more people to listen. I hope you're able to listen to her and to everyone she speaks for, and that you are able to help the people that desperately need you to make a change. The first step would be an overhaul of Jefferson County DSS and CHJC. Thank you.
My name is Greg Bush. I've been with Jennifer Constance for over 21 years. This woman has spent hours and hours and hours of paperwork, study. It took courage for her to come here today. She's a senior staff with Jefferson County Department of Social Services. That was not easy for her. I told her to do it years ago. We have to do something. I've watched people gloat over this, Jefferson County employees. I was present when the DSS attorney said F you, F you, F you several times to our attorney, Jennifer's attorney. All you want her to testify to is for lawsuit purposes. As Jennifer said, if she wanted to sue, she would have sued a long time ago. Liz Doherty, what she said, I worked with Liz many years, a lot of DSS cases. I've seen DSS fail, and I've seen them succeed. But I don't know what's going on the last few years here, but it seems like failure is what's happening. Kids are going through the cracks. I don't know where the cracks got to be filled, but they have to be filled sooner than later. You probably all know what I did for a living. I did it for 25 years. I've seen kids die because DSS messed up. This woman over here, Jennifer Constance, not because I've been with her 27 years, I've watched her do what she's done, the pain, the suffering. When that little girl comes to our house, or she calls me Grandpa, Grandpa, when can I come back? Grandpa, I love you. Are you my real grandpa? That little girl is living a double life. A double life because of things that happen at the DSS level. A double life. She doesn't know who her mom or father is. Some days, we try to get her involved in her mother and father's life as best we can. And it's her siblings. These little girls come over to the house, they love getting together. Does the person who has custody right now, Kendall, does she care about that? No. She makes no effort to get these kids together. She makes no effort to find out who her relatives are. She makes no effort to let that little Kendall call her grandmother when she wants to. There's times when the call is supposed to be made, Jen calls, no answer. See, this person who has custody of this child right now holds all the cards, and she knows it. Now, cards are being held by her because the Department of Social Services made major mistakes. Major mistakes. And the integrity of that agency, I don't know what's going on, but as it's been said tonight, is not good. Not because I'm involved in it, because my past. Something has to be done. How many times have people come up here and explain to their cases about things that are falling through the cracks? And God knows, if you don't have the resources, if you don't have the finances, there's nothing you do. Nothing. Whatever is said is said. Whatever is done is done. And that judge over there, she weighs heavily on what Child Protective tells her. I don't know where Judge Hunt is, but I wish he'd come back. He would not tolerate this. Would not tolerate this. When you're given facts, and when you talk about things in court, and when you're shut down, I even testified to the mental capacity of the person who has custody of Fort County. Suicide. You think that was taken seriously? No. Did DSS ever ask her? She ever had mental problems? Apparently not, or she lied. If they had come to Jen, we could have told her, oh yes, there's some issues there. Alcohol. This girl gave, I don't know how many pictures to the court of alcohol around kids, Kendall, handing people drinks, people peeing in front of her. Party after party after party. You know what we get told? Well, we can't prove that that person's really drinking that beer when they're holding it out there. That's right. That's what a magistrate, referee, or call said to us. In court, open court. And Jefferson, he's not going to see Jefferson County being taken down. What kind of language is that? Because he's being fed a bunch of crap from the Department of Social Services about this case. And the crap is, well, you know, it's an oversight. An oversight? That's That's the only excuse you have is an oversight? This little girl belongs with her family, her true family. Her last name is Constance. It's not Brown, it's not Smith. This little girl was dragged all over Jefferson County. Well, this is your uncle. This is your aunt. They're not even related. This little girl needs to be with her family. And that woman, tirelessly, night after night, is up working this case. I don't know where this is going to go, guys, but I'm telling you right now, it's not good. Because we're not going to stop. We're not going to stop until Kendall is where she belongs. She belongs with family. Because this could happen to any one of you guys in here. DSS gets involved, CPS worker doesn't cross her T's, doesn't dot her I's, or it's a guy, whatever, there are guys and girls there. And there's some great workers here, don't get me wrong. But something is wrong. It's broken. And these little kids are kind of all responsible for it. And this little girl, Kendall, if something happened to her in the care of this person she's with, no hell is okay. That's what we worry about. So please, take to heart what Jennifer had to say. She's smart. She knows the law. She's dedicated. She loves Jefferson County. And what her mother said, I'm hearing this. She doesn't want to go to work anymore. Senior staff meetings. You know how embarrassing that's got to be for her to go to these senior staff meetings with the same people that have tried to screw her over? That is one heck of a ridiculous being. And she just eats it and eats it and eats it. We've encouraged her to come here. She came here. It's up to you guys. And like Liz says, I think there's definitely should be an inquiry of what is going on over there, especially Kendall's case. People who sign a document that says it, and it's not true, it's not only fraud, it's a crime. It's a crime. So please, get this little girl back to her family where she belongs. You guys haven't got the power to do that. We understand that. But there's problems over there. These two DSS attorneys, there's no accountability. No, who do they answer to? They don't answer to Dave. Why aren't they answering to Dave Paulson? Okay, I guess I gotta calm down and say goodnight, guys. Just understand, it's a big passion of ours to get this little girl back where she belongs, so, thank you.
Thank you. Is there anybody else that would like to speak to the board? Seeing none, we'll close the open privilege report. We'll move on to approval of the minutes. Changes or additions, deletions to the minutes from the previous meeting? Seeing none, we'll approve them as they are. Now on to resolutions.
The first resolution of the evening is authorizing agreement with the City of Watertown for transportation services for the elderly.
Can I get a motion, please? Legislator Peck, second. Legislator Clarko. Any discussion? All in favor? Aye. Opposed? Carried.
Next is accepting New York State Office for Aging and American Rescue Plan funding and amending the 2022 county budget relation thereto.
Motion, please. Legislator Reed, Legislator Peck. Any discussion? All in favor? Aye. Aye. Opposed? Carried.
Accepting New York State Office for the Aging and American Rescue Plan funding and amending the 2022 county budget relation thereto.
Motion, please. Legislator Clarko, second. Legislator Drake. Any questions? All in favor? Aye. Aye. Opposed? Carried.
Amending 2022 county budget to allocate additional state aid for community services, mental health programs, and authorizing amendment agreement in relation thereto.
Motion. Legislator Grant, second. Legislator Reed. Any questions? All in favor? Aye. Opposed? Carried.
Amending the 2022 county budget to accept additional funding for Veterans Peer Support Pilot Program and amending agreements in relation thereto.
Motion, please. Legislator Barco, a second. Legislator Grant. Any questions? All in favor? Aye. Opposed? Carried.
Amending the 2022 county budget to allocate additional state aid for mental health programs and authorizing amendment agreements in relation thereto.
Motion. Legislator Peck, second. Legislator Drake. Any questions? All in favor, aye? Aye. Opposed? Carried.
Amending the 2022 county budget relative to additional revenue from the New York State Office of Children and Family Services for enhanced adult protective services.
Motion, please. Legislator Barco, second. Legislator Drake. Any questions? All in favor, aye? Aye. Opposed? Carried. In close, you'll see some departmental reports. Other than that, is there any unfinished business, questions, comments? Anything anybody would like to talk about? Seeing none, a motion to adjourn. Legislator Drake. Legislator Barco.
think you're right. That means that they're captured if it's 6 months.
the back, could you take it downstairs? So we can run our meeting? Well, I'd like to be quiet. Can we have a quiet, please, for our meeting? Thank you. Yeah, come in, come out, it's fine. We're gonna run a meeting. I got you, Mike. Thank you. I'd like to call the meeting order now. Okay, privilege of the floor. Anybody? Approval of the minutes. Discussion, any concerns? No, they'll stand as, they'll stand as, printed. Agenda, oh God. Finance rules sponsored resolutions.
First resolution, payment of legislative expenses.
May I have a motion, please? Legislator Drake, Legislator McBride, discussion on the motion. Hearing none, all in favor?
Aye.
Opposed? Carried.
Next, approving mortgage tax report.
Motion, please. Legislator Paris. Legislator Gray, thank you. Discussion. Hearing none, all in favor?
Aye.
Opposed? Motion is carried.
Next is amending the 2022 county budget relative to records management.
Motion, please. Legislator McBride, Legislator Cantwell. Discussion on the motion. Hearing none, all in favor?
Aye.
Opposed? Motion is carried.
Amending the 2022 county budget for insurance.
Motion, please. Legislator Calarco, Legislator Ferris. Discussion on the motion. Hearing none, all in favor?
Aye.
Opposed? Motion is carried.
Authorizing agreement with Jefferson County Industrial Development Agency in relation to the American Rescue Plan Act.
Motion, please. Legislator Ferris. Legislator Campbell. Discussion on the motion. Hearing none, all in favor?
Aye.
Opposed?
No.
Two opposition. Motion is carried.
Authorizing a municipal agreement with the city of Watertown regarding Coffee Street construction project.
Motion, please. Legislator Drake, Legislator Ferris. Discussion on the motion. Hearing none, all in favor?
Aye.
Opposed? Motion is carried.
Next is adopting guidelines and administrative procedures in relation to the county's housing improvement program funded by the 2021 New York State Community Development Block Grant Award.
Motion, please. Legislator McBride, Legislator Campbell. Discussion on the motion. Hearing none, all in favor?
Aye.
Opposed? Motion is carried.
Approving appointments to the North Country Home Consortium Administrative Board.
Motion, please. Legislator Calarco, Legislator Ferris. Discussion on the motion. Hearing none, all in favor?
Aye.
Opposed? Motion is carried.
Reappropriating New York State Governor's Graphic State and Child Passenger Safety Grant relative to the Sheriff's Department and amending the 2022 county budget relation thereto.
Motion, please. Legislator McBride. Legislator Gray. Discussion on the motion. Hearing none, all in favor?
Aye.
Opposed? Carried. The Health and Human Services Committee sponsored resolutions that happened 3 minutes ago, so I'm sure you all remember those. And I would ask that we do them on one vote, unless this person wants them pulled out. I'd ask if you could to read those.
Oh,
I'm sorry, should this be, this,
yeah, we have that to do as well, yeah.
should that happen before?
Let's be radical and have it happen now.
Happen now. Okay, resolution number 10, under the financial rules agenda. As you all got an email this evening, now we've passed out this resolution. Could I have a motion, please? Legislator Ferris, Legislator Gray. Discussion on this motion. Hearing none, all in favor?
Aye.
And opposed? Motion is carried. Thank you. Back to Health and Human Services.
Yes. Accepting New York State Office of Aging American Rescue Plan funding and then the 2022 county budget relation thereto. Oh, I'm just right. accepting New York State Office of Aging American Rescue Plan funding and amending the 2022 county budget in relation thereto. Next is amending the 2022 county budget to allocate additional state aid for community services and mental health programs and authorizing amended agreement in relation thereto. Amending the 2022 county budget to accept additional funding for Veterans Peer Support Pilot Program and amending the agreement in relation thereto. Amending the 2022 county budget to allocate additional state aid for mental health programs and authorizing amended agreements in relation thereto. And amending the 2022 county budget relative to additional revenue from New York State Office of Children and Family Services for enhanced adult protective services.
Have a motion to move those. Legislator Clark. Legislator Carewell. Any discussion? Legislator McBride.
Yeah, I think it's resolution number 5. I'm not in support of giving money to the children's zone. 26,588 and 33,310.
So would you like to pull that and vote on that separately?
That one.
Sure. Any other, yes, Legislator?
I would agree with my colleague across. I would not supporting the children's home in Jefferson County in any way at this particular time.
So we'll pull it and then you can vote as you will. So we'll vote on 1 through 4 and 6. Everybody agree? All in favor?
Aye.
Opposed? They're carried. So now we'll vote on motion, or excuse me, motion number 5, correct? 5? Okay, so all in favor of 5?
Discussion?
Oh, well, I thought we had a discussion.
Yep.
Further?
Yep.
Thank you, Mr. Chairman. In the past few months, we've had multiple discussions, trying to work on helping certain families out in our county, and I don't feel like the Children's Home of Jefferson County has been doing a better job or did their job appropriately, so I will openly be opposing them for any part of Jefferson County.
Any further discussion? Okay, so we're voting on just number 5. All in favor?
I think it's 6.
Am I reading it wrong? Number 6.
No, it's number 5 on your list, on the finance list, is what's on how
We're not
you...
going back.
Oh, okay.
You can't look at how the service agenda is moving your budget was.
I matched the word health programs and all.
That's the one that represents 5.4% population.
Yeah.
Yeah, and that's number 5, right? We're talking about the same one. I'm not normally up this late, so I'm a little... Hand over here. Legislator Gray?
Just perhaps would a motion to table it be in order, or,
It's already gone through committee. You're talking about health and human services.
Right.
Yeah.
Yeah, we're not talking about a finance resolution, we're talking about something from health and human services.
It will move forward.
So it'll move forward,
It's
yes.
passed to Health and Human Services to full board next week, regardless of what this will.
so it'll move forward with an affirmative vote from the Health and Human Services and a negative recommendation from the finance rules. Okay. And so we just passed a resolution, correct?
No, we're about to vote on it.
We asked the Health and Human Services Committee just passed the resolution.
Yes.
So, are there any hybrid members that are of both committees?
Sir?
Pardon?
I'm both committees.
Yeah, Legislator
That's
Gray,
all I'm saying.
Legislator Clark.
You're going to have conflicting votes from some people if they're changing their votes right now. That's all I'm saying.
Legislator Gray?
What about the $129,000 for the mental health? You gonna toss that aside too, or?
We did that.
You already approved it.
Yeah.
So you're just tossing out the children's homes part of the resolution?
Right. These 6 resolutions are before the that agenda is different. If you're not looking to endorse, we would then move forward. Clearly, it's going to go forward with full board, but then it would be with or without the endorsement of finance committee, which I'm not sure right now. That's the answer.
Health and Human Services already approved this. Legislator Clarko?
I just want to make one point, that this is a cost of living adjustment, it's not endorsing or not endorsing. So whether we approve it, if we don't approve it, it's just not approving it for the cost of living adjustment. I just want to bring that to everyone's attention.
Legislator Gregg?
It's amending the budget, right?
Yeah, right.
Which requires the Finance Rules Committee to act on. So,
To endorse or not endorse, but the action is already happened by way of the health committee.
right. But the Finance Committee is the one that has to, the only reason they're entertaining.
You're not going to discuss the
budget.
Correct. Yes, that's right.
You're not giving them the money. You're not okay. Right?
Any chance we can go to privilege of the floor? Legislator Ferris?
I would be supporting this if you pull the children's home out.
Now you're talking an amendment.
Yeah.
That would have to come up on board, right?
I don't, I'm going to understand that, David, but I don't think we have that authority for finance. I understand your point.
I understand.
But I don't think we
I'm just
have
making
that
a statement.
to amend full board. You can though, right? Full board. You can vote up or down, or amend, yes, you can.
Another thing to keep in mind too is, we've heard complaints about children's home and their foster care programs. This is having to do with the program they provide for mental health services, which is very different. I don't think we've heard that mentioned, and I don't know that we should lump them together. Just point that out for your consideration.
Anything further, Legislator Gregg?
So the funds are coming from the New York State Office of Mental Health. If I'm correct, Mr. Counselor?
That's correct, yes.
So let me just clarify that I believe, if Counselor's question, I believe they can just fund them directly. They don't have to come to us.
I don't have the answer for that.
Right. So again,
We can find out.
I don't know the procedure. So it's my understanding,
We were sitting on the board, so you might.
So it's probably more of a question for Mr. Britton.
Yes.
But it's my understanding that the state can fund them. I could be incorrect, but the state can fund them directly. If we choose not to fund them, which is really what the desire is over here, and this is appropriately pointed out, it's just a cost of living increase. We're already funding, it's already coming to us. So the state can contract directly with them and bypass us, I believe. But I would like that clarification before the full board meeting.
Well, thank you for making that point, but nonetheless, we still have to vote on it now, right? This is where we are.
I'm just saying it may not stop it. Our declining this resolution may not stop the funding. It just may not come to us.
Right. Those who are concerned have been informed, thank you. So unless there's further discussion on this, can we vote on it? Legislator Clark?
I just want to point out to my colleagues that it is affecting other agencies. It's just a cost of living increase. It's already in the budget. I don't think we can undo what's already been done. I don't think you can take it out of the budget by saying that you're not acknowledging the cost of living increase. It's a fact of life in this budget. Isn't that correct?
This is above and beyond what has been funded already because it's an adjustment. Yes.
Anything further? All in favor? Opposed?
No.
Well, I guess the motion fails and then goes forward with a negative recommendation from us. We've covered all the things that are on the agenda. Anything further? Then I entertain a motion to adjourn. hand, thank you. Right. All in favor? We are adjourned.
It's